I'm joined by my colleague Mitch Englander. This is the Planning, Land Use and Management Committee. And we have about 5 items on the agenda today. Before we proceed, we will, with the concurrence of Mr. Englander, continue item number 3. That item has been, there's been a request to continue that item at the request of CD4, so we will continue to Plum on February 28th.
Is that a vote for them?
Is that okay with you, Mr. Englander? And okay, so we'll continue that item. And if we could now go to the Planning Department. Want to do the report now, or do it at the end? If there is there a report? No report today. Want to do it now? Let's do item number 5 now, Mr. No, I'm looking over here, Mr. CLA. I was going to call him. If you want to read that item, please.
Sure, Councilman. It's item 5 is the Director of Planning's weekly report, and Mr. Bell is present.
Okay.
For the record, a lot going on within the Planning Department. Very busy 2012 so far. One of the most exciting initiatives that the Planning Department is undertaking has to do with planning around transit-oriented development stations. We have a $3 million grant from Metro to do station area planning for the Exposition Line and then also for the Crenshaw Corridor. So we are in the process of reorganizing the Planning Department and gearing up and ramping up for this very significant initiative. Also in the grants department, we did receive from the Public Health Department a $1 million grant, a community transformation grant, to begin work on what is called a health chapter of the general plan framework, and this would look at ways in which we can adopt policies and regulations to improve the built environment because of the connection that we see between people's health outcomes, improving pedestrian access, improving transit access, regulation of tobacco retailers. So we're very excited about undertaking this particular initiative. We also received some funding from the Department of Transportation to implement the bike master plan, and we will be starting work on that particular initiative within the next few weeks, particularly to doing the actual CEQA approvals for implementing the bike plan that the council adopted last year. Following the success of the Hollywood Community Plan, we have 6 additional community plans that we are working on that we will be presenting to the Planning Commission. So this is covering approximately 1/3 of the city. So we're very excited that we have made significant progress in developing these community plans. All of our community plans, for 35 community plans, are more than 10 years old, so long overdue. So we think that this is a very significant step in the right direction. And then the department is grappling with the issue of the dissolution of the redevelopment agency. We'll be making an oral report on that, on the consequences of the dissolution of the CRA today. So that concludes my report.
Thank you very much, Mr. Bell. Any questions or comments from Mr. Englander? No? Thank you for your presentation. So we will now go out to item number 1.
Yes, council members. Item 1 is a verbal report from the Planning Department in conjunction with the city attorney in response to a motion Wes and Reyes. Motion has been adopted by the council requesting that an ordinance be prepared to transfer the land use powers held by the CRA.
Thank you.
Good afternoon, council members. Ken Bernstein with the Policy Planning and Historic Resources Division of the Department. We did want to come back to you on this motion and begin with an oral report to seek your initial policy input on this very important topic. As you know, the Community Redevelopment Agency was dissolved as of February 1st, 2012 as a result of the state legislation AB 1X26 and the recent California Supreme Court decision. You had had at the council level an initial policy discussion on this and elected not to assume successor agency status to the CRA-LA, but left undecided and not so focused on in the initial aftermath of that Supreme Court decision is what happens to the land use regulations that are associated with the redevelopment agency. And that is really the focus of the motion that was presented, the Wesson-Reyes motion, which instructed our department to prepare an ordinance that would transfer or preserve the land use powers of the CRA through policy adopted by the city. We have begun meeting in conjunction with staff members of the CRA-LA, representatives of the Office of the City Attorney, to work through a number of these issues. The CRA-LA, as I think you know, has transitioned to what is called a designated local authority, or a DLA, which is now under the jurisdiction of state appointees, because the council did not accept successor agency status. A 3-member board has been appointed by Governor Brown and has begun meeting. But considerable uncertainty still remains about the status of the CRA's land use controls and various land use incentives and how those will be implemented in the future. There's considerable uncertainty within the development community as to how these will be implemented. And we wanted to just quickly walk you through some of the major issues, areas of concern, and present to you a range of potential policy options before we report back in writing. I think the important point to note is that while the state legislation, AB 1X26, did dissolve redevelopment agencies and eliminated the economic development tools, tax increment financing, the ability to assemble property, it did not abolish the redevelopment plans that were associated with those redevelopment project areas. The project areas themselves remain in place. There are 31 redevelopment project areas across Los Angeles' communities, and the redevelopment plans associated with those were not eliminated, and the belief is that those remain in effect. Those, therefore, kind of continue to exist as expressions of public policy in the city. Those plans were adopted by the city council, and they contain land use designation and authorities that were granted in those plans that remain effective until their expiration dates. And in many cases, those expiration dates are still 20 years off or many years in the future. So at the moment as well, CRA-LA staff, now the staff of this new designated local authority, remains in place for a 120-day period that was provided for under the existing MOUs. That staff is continuing at this moment to perform the land use reviews that are associated with those redevelopment plans. But we certainly believe that after June 30th of this year, that staff, or much of that staff, may no longer be in place, and the city needs to have a policy and an approach for how those land use components will be pursued moving forward. And that's been the subject of our land use working group that I mentioned. There are several areas that are affected by this. First and foremost are provisions related to the redevelopment plans themselves, land use provisions within those plans. Most of the 31 redevelopment plans have special land use controls and regulations that indicate that actual development permits cannot be issued without some level of sign-off that was formally performed by CRA staff, that was ensuring that those development proposals are consistent with the redevelopment plans. And these plans, therefore, have very significant protections for local communities that include regulations on development scale, use, density, parking issues, urban design and building design regulation, and historic preservation protections. And these are land use tools that have been in place because the CRA was focused on many of the city's most economically distressed areas. These are tools that in many cases have been the only local land use regulation for some of the city's most economically disadvantaged communities. These are large sections of the central city area, downtown Los Angeles, Hollywood, many parts of South LA. So for example, this has been the only regulation we've had in South Los Angeles for many of the commercial corridors and hubs. In downtown Los Angeles, we now have a community design overlay on Broadway that is performing historic preservation and design review on Broadway itself, but we've had no design overlay on all of the adjacent streets of the historic core, on Spring Street, on Main, on the numbered streets. In North Hollywood, we have specific regulations for design review, pedestrian orientation, and scale. So all of these have been embedded in the redevelopment plans, and we need some approach to ensure that these are implemented going forward if the plans remain in effect. A second area, in addition to the redevelopment plan provisions, are the zoning code references to redevelopment. Our municipal code contains literally as many as hundreds of references to the CRA, LA, and to redevelopment plan boundaries, and everything having to do from a range of parking requirements to regulations on superstores in the city. So these references to redevelopment in the zoning code need to be cleaned up or addressed. And then a third area that's of much concern to property owners and members of the development community are development rights that have been conferred by redevelopment. In many areas, in some redevelopment areas, there are requirements that the CRA LA board take action to allow developers to maximize their property rights. So there may be some base level of density, for example, that might be permitted, but to go above that would require an action by the CRA board. So now the CRA board is this three-member DLA appointed by the state. Their primary purpose is to wind up the fiscal affairs of the agency, and not necessarily to review the appropriateness of additional density for a land use proposal. So there are many examples of this around the city. In downtown, Chinatown and Little Tokyo are among the plan areas that have this requirement that to go above base density, CRA board approval is necessary. So all of this remains in effect. This has been adopted by city ordinance, and at this point, we are, as a department, seeking guidance from the council as to whether the council wishes to continue enforcing these review protections and local provisions. The Department of City Planning obviously has the expertise to perform these land use reviews. However, as you know, given the budget situation of the department, the significant loss of staffing, this would potentially require additional resources. But there are also opportunities associated with this, the opportunity to avoid duplicative review that has existed in many cases in the past. We've had planning department review of development projects and the CRA performing a planning and land use function, the opportunity to avoid that duplicative review and to be consistent with our ongoing development reform efforts to streamline review of development in the city. So what we wanted to present to you today, and we're happy to come back with a written report within the next couple of weeks, are three potential transition scenarios. The first would be to do that limited cleanup that I mentioned previously of the zoning code references to redevelopment, the municipal code references, to shift those references of decision-making authority that mentioned CRA LA potentially to the Director of Planning and the Planning Commission. This is not something that we believe has a fiscal impact associated with. It would be a cleanup provision addressing zoning code inconsistencies. A second option, which could have fiscal impacts, would be to incorporate all redevelopment plan land use authority, permit authority for the redevelopment plans, and to shift the review of those plan provisions from CRA to the Director of Planning. Again, because that gets into a permit level review, doing design review, reviewing use, potentially historic preservation review in other areas, that is something that would have a significant fiscal impact and would require additional staffing. We are happy to flesh that out further and bring you recommendations if that's something you would like to pursue. And then a third area, a longer term work program, would be to continue to have the CRA's advanced planning work by adopting transition ordinances for our redevelopment plans. We have done this with begun doing this with some of our downtown area plans that have been expiring or were soon to expire, such as in Bunker Hill and in Little Tokyo, where we've been transitioning some of the regulatory controls that CRA has had into some of our overlays and other planning tools that we have at our disposal in planning. That would take several years most likely to transition all 31 of these redevelopment plan areas into similar overlays and controls that we have at our disposal in planning, but that is a third option available to you. So based on all of that, we wanted to kind of lay these issues out initially to you today. We are happy to come back with a written report, but we wanted to seek your initial policy guidance as to whether to pursue this approach to potentially consider centralizing this land use review within the Department of City Planning to avoid duplication and achieve many of the protections and streamlining goals that I've mentioned. So thank you very much.
Well, thank you for your report. And my initial reaction would be that, yes, we would want these land use powers to be transferred over to the planning department. But I have some reluctance in doing that, in that I don't think the council or the city has had an overall discussion about what agency, if any, are we going to create a new department? Is it going to be CDD? Is it going to be planning that will take on the majority of the responsibilities that the CRA was doing in the past, and who will be the economic development driver for the city in the future? And I'm not sure if we're piecemealing some decisions right now rather than taking on the issue as a whole. So are those issues you've discussed amongst yourselves with the makers of the motion, so that we're not piecemealing and going in a direction that may or may not be compatible with the overall comprehensive plan to move forward on what will drive economic development in low-income areas?
I think historically that in a sense, we've had two planning agencies in Los Angeles, and we have deferred to the redevelopment agency to do the land use planning in redevelopment areas. What has been unique is that the CRA has land use authority even when they're not making a financial investment in a particular project. So even if a project is not getting any public financing, not getting any kind of a public subsidy, but they want to build in a redevelopment area, they still have to meet the land use controls and zoning that's in that redevelopment plan. So our view that it's a natural fit. The mission of the planning department is to manage land use controls, to administer the redevelopment, to administer the general plan. So it seems a very natural fit to kind of transfer and merge those planning functions all within one agency, namely the Department of City Planning. It will provide a much more efficient regulation of land use. You won't have two agencies that you have to go to. You won't have two sets of planning staffs. You'll have one planning staff. But I think what Mr. Bernstein's point is making, and I think this has come up in our working group meetings, is that all of these land use controls have been adopted by the City Council for very valid policy reasons. They provide important protections for the communities. And the main question is, do we want to continue those controls that are important for community betterment? And then if so, what's the best way to make sure that there's no gap in the administration of those regulations?
Gotcha. I got that now. So is your request that you come back with a written report on the policy, or to go back and not only do that, but also come back with an ordinance that will implement or allow this to happen? I'm not quite sure what the request is.
I think we're prepared to come back with a report really looking at a two-pronged approach. One could be this immediate kind of cleanup ordinance, which was in some ways the focus of a portion of the initial motion. But we're also prepared to come back very quickly with a written recommendation that includes a projection of potential staffing or funding needs to fully perform the redevelopment plan related reviews. So we can look at both of those simultaneously. Okay. We would also point out that the city has been receiving funds back with the end of the redevelopment agency, the tax increment funds that had been essentially previously retained within the agency have been redistributed back to those taxing entities, including the City of Los Angeles. So there are resources that have are flowing back to the city. Certainly what we're looking at is a very small percentage of the funding that is coming back to the city to enable us to continue to perform the land use related reviews that have been important to many of the communities throughout Los Angeles.
Okay. Any questions, Mr. Councilmember?
Just a couple. First, thank you for the report, Ken. Appreciate it. With that, it doesn't sound to me, or perhaps some clarity on, since the state failed to or did not dissolve the city's policies on those areas, do we have to actually take an action to preserve those, or is it simply automatic with the cleanup language that you're proposing?
I think everyone's belief is that because there was no action to invalidate them, the plans remain in effect.
Okay.
The question is, though, what steps will we take to actually oversee or implement those plans?
And then that part of it on funding issues. What's the staff, the current staff? How many staff members are there?
At CRA,
yeah.
About 190 staff are remaining at CRA LA. But
so is there a staffing plan that will be part of your written proposal, or that will come under separate cover to a different committee or to the personnel committee with the funding and probably the budget committee?
Well, right. We are happy to report back to Plum Committee with our staffing plan. I think our expectation is that could be also jointly referred to Budget and Finance and or Personnel Committee once we come back with that.
I mean, some of the preliminary numbers were maybe like 15 to 20 CRA staff were actively administering and overseeing the land use controls and doing sign-offs for building permits and making sure the plans conform to the plan.
So what happens to the other 150?
Most of those staff will no longer be working for the CRA. And again, the CRA LA, as now a designated local authority, will essentially be becoming an asset management entity. They won't be performing their former core mission of economic revitalization, removal of blight, and so forth. They'll mostly be winding down their fiscal affairs. So I think what we're looking at is a very small subset of the current staff that has been devoted to the planning activities of the agency, the land use related activities, and trying to estimate what those needs would be if those functions were to be performed by the city.
Okay. Thank you.
Thank you. Well, all the questions that were asked and it will be contained in your written report, right? Once you get back that written report, some of the information will be there. And so why don't we do that and refer this to staff and come back in how long for the report?
I think we'd be prepared to come back in 2 weeks at the meeting of the 28th, if that agenda.
That sounds good. We'll be back in 2 weeks with that written report so we could further discuss this. Thank you.
Great. Thank you.
Thank you. So we'll dispose of that item to refer to staff. And next item, Mr. Mejia.
Yes, Councilman. Item 2 is a CAO report. It's relative to a building and safety request for funding from the Construction Services Trust Fund for Phase 2 of the Internet Document Imaging System.
Good afternoon. Melissa Fleming with the CAO. This item is a request from Building and Safety for $769,434 in funding from the Construction Services Trust Fund. The funds will be used to convert all historical building permits dated from 1950 to 1960 from microfilm to digital images, and that's a total of about 706,000 building permits. The Construction Services Trust Fund receives revenue from a 2% surcharge on all transactions that occur at the city's construction services centers, also known as the one-stop centers. Excuse me. The role of the CAO is to review funding requests to ensure that they meet the criteria for funding from the Construction Services Trust Fund, as expenditures from the fund must be made to support or enhance the services that are provided at the one-stops. As this particular request will make these historical building permits more accessible for the public, thereby reducing wait time for the applicants at the one-stops, this request meets the funding criteria and is therefore recommended for approval.
Great, thank you. The CAO, your report notes that there are still 5.4 million documents dated from 61 through 2004 that will require digital conversion. So why so from 1950 to 1960, with these funds, you will complete those? Would there be any more from this time frame that need to be converted?
So the request itself for right now is from 1950 to 1960. The department has been receiving funds from the Construction Services Trust Fund over about the last 10 years for this particular project, and so far they've gotten up to 1960. So you're right. After that, they will have approximately 5.4 million more documents that would need to be converted, which I think initial estimates were that would cost at the current level, if the costs were to remain consistent, about $6 million.
Okay, and the trust fund currently has 5.4 million. What other uses is this trust fund used? Is it used for anything other purposes? What are the opportunity costs of putting the money into this digital transfer versus something else?
So the fund, as of right now, I took a look at it today, has about $6.6 million in available funding. So if this particular fund or this particular request were to be approved, that would leave $5.8 million. Departments, any department that has a presence at the One Stop Center can come forward to the council to request funding from the Construction Services Trust Fund. This particular request obviously was presented by Building and Safety, but any item that were to meet the criteria in that it would assist any participant at the One Stop, the departments could come forward requesting funding for that.
Thank you. Councilmember Eglander?
Yeah, just a quick question. Thank you for this. First, my question is on the maintenance of the system. It looks like in phase one, it was already at the $455,000 for the hardware that was purchased in 2001. What's the cost of securing and maintaining these files once they're in the system?
So the funding from the Construction Services Trust Fund has been provided just for the initial, so first for the equipment, but then the costs that are being requested at this point in time is actually for a contractor that provides the service for the department. The department's Building and Safety Building Permit Enterprise Fund actually maintains the equipment that is utilized, so I would need to defer to the department to know the cost of the
So they haven't weighed in on it, what
that.
the cost would be for any maintenance?
For the maintenance cost, I mean, there is existing maintenance cost that's being funded by the enterprise fund. I'm not sure what that cost is.
Okay. Well, I guess the real question, though, then goes back to and forgive me, I'm new to the committee, so I'm still learning about all these little funds and resources and what they're used for. So with the CSC, which is the Construction Services Committee, it says that that is in the process of restructuring, is not expected to meet in a timely manner for this. It was being forwarded without their consideration. When was the last time they met?
The last time the Construction Services Committee met, I believe, was in early 2009. At that time, there were, I believe, some conflict of interest issues that came forward to the Plum Committee associated with the Construction Services Committee. At that time, there was discussion and there was a request to the city attorney to complete an ordinance to, I believe, restructure the Construction Services Committee in order to address those issues. I don't believe that ordinance has come forward. Since then, we've discussed the situation with the city attorney because departments have still requested funding, and in the past, those funding requests would have had to go to the Construction Services Committee beforehand. The city attorney indicated that all funding requests should be forwarded directly to Plum for approval and then subsequently to the full council.
So it's been 3 years since the committee has actually met.
That is my understanding. I believe the last meeting was in early 2009.
Okay. And what's the time frame now to get that resolved so this doesn't happen again?
I'm to be honest, I'm not sure. That would be a question for the city attorney. I believe there is a pending ordinance on that item.
So there's a pending ordinance, but
Correct.
it's the city attorney shortfall financially where they've on 36 furlough days and falling backwards on ordinances that
I'm not sure the status of this particular ordinance.
I guess. Okay. Okay. Thank you.
All right. If there's no objection, we will approve the CEO recommendation to allocate $769,434 from the Construction Services Trust Fund for the conversion of building permits dated from 1950 to 60 from microfilm reels to digital image to continue Phase 2 of the Department of Building and Safety's Internet Document Imaging System. And is this going to Council or to Budget and Finance? Do we know?
Mr. Chair, it goes to council after this.
Okay, great. Thank you very much. Okay. Is seconded, moved by Mr. Englander, seconded by the chair, and no objections so ordered. Thank you. Next item.
Item 4 is the next item, council members. It's an appeal filed by Niles and Alyssa Wiltz. They're actually appealing the action of the zoning administrator, which approved a conditional use to permit an existing synagogue in a R1 zone. There's also a Section 245 motion introduced by Councilman Stein associated with this action, Councilor. And the associate zoning administrator is present.
Thank you. Is staff here to present this item?
Yes, Mr. Nicholas Brown.
Councilmember Huizar, Terry Kaufman, Macias City Attorney's Office. Just to clarify where we are procedurally, since we're on a assertion of jurisdiction under Charter 245, this committee stands in the same shoes as the Area Planning Commission. So that's the first thing. So your standard is on appeal is if the zoning administrator erred. That's the first thing. And then just briefly, some of the issues that have been raised in this case, I just want to frame it very quickly, relate to what we refer to as our LUPA, which is the Federal Religious Land Use and Institutionalized Persons Act. Right. And what that act basically says is that land use regulation can't impose a substantial burden on the exercise of religion. Regulations can be justified based on compelling governmental interest, and the exercise of that has to be done with the least restrictive means. But that's kind of where we're at. It can't treat religious applicants differently on less equal terms than non-religious applicants.
Okay, great. Thank you for that clarification. And just to be clear, we will hear now from the zoning administrator. We also have the applicant who wishes to speak, whose name is David Carlat. And we have Niles Willits Spollen, the appellant. Yeah. And then we have Daniel Skolnick from CD3, right? So, but first we'll hear from the zoning administrator.
Good afternoon, Nicholas Brown, Associate Zoning Administrator. Just in a way of background, the case that you have before you was originally heard in 2004 by the then Zoning Administrator, Anique Sharon. What was presented to her was a case where there was the illegal conversion of a single-family home to a place of worship, and therefore received a citation by the Department of Building and Safety. Upon making the application for conditional use and conducting the public hearing, the zoning administrator initially heard that there are approximately 20 congregants that were in this facility. However, after listening to the full testimony, realized that this was much larger and had far more impact to the surrounding community than just 20 congregants. But she decided that there was no way for her to mitigate the impacts, so therefore she denied the project. It was then appealed to the Area Planning Commission, South Valley, and it was at that time when the city attorney sat with our APCs and did instruct the APC, similar to as you were constructed today, that there is a Freedom of Religious Act that we have to, and as stated, these are the parameters. The APC at that time decided to overturn the AZA and approve the project. It was 245. The 245, during that period, the applicant was able to obtain legal representation, and with that legal representation went to the city council, was able to get conditions that allowed the intensification of the use beyond what the APC originally approved. The city council also had two conditions on there. One was that there will be an approval of plans review. The other was that this will automatically expire, meaning the conditional use, if they did not meet the condition for public safety or pedestrian safety. In both accounts, this applicant did not comply with the conditions. They did not come back for an PA, approval of plans, and even though they did not meet the requirement of the code, the condition of the approval to provide the public safety component, they still continued their operation until cited by Building and Safety, and that is when I heard the case. I conducted 2 public hearings, and during that time, I heard testimony that clearly showed that it was beyond not only what was originally considered, but also beyond what was originally approved. The expansion of space from 7,000 square feet to 2,800 square feet, and the number of people that would at one time be on the site. I worked with the applicant's representative at that time, which is not the same as today, and we were able to come up with a set of conditions that we thought would work. I approved, and this was appealed by a neighbor who thought that the conditions were not strong enough. And it was at APC that APC made some additional changes, and now you have a 245 before you. I have, within my submittal, addressed all the 8 contentions of the applicant, and of those, there are 3 that I think should be considered for modification. One is the hours of the operation in the morning. That would be number 4. Now, when the applicant came to the APC, they worked with the neighborhood and volunteered to reduce their hour at night from 11 as approved in my determination to 10. It was later, as the hearing proceeded, that they realized that, wait a second, I also had a condition limiting them to anything starting before 7 a.m. They asked the APC if, since they have given an hour in the evening, if they can have an hour in the morning. Without deliberation, APC said no. So the request in the 245 motion, I think, is very appropriate, and I believe not just because of the freedom of religion, but also because they were willing to give an hour in the evening, we should give them an hour in the morning. The other is the contention number 3, and this is related to the outside activities. Now, we don't know what it is that they want to do outside and what times they want to do it. And until I know what they are proposing, I don't know how to advise you, how to ensure that whatever activity there is going to be mitigated to where individuals in this R1 neighborhood can still enjoy the rights and freedom of having a peaceful and quiet environment, especially in the evenings as they are proposing. So with more information, it is possible I can better advise you on that contention. The other is their contention number 6, and this is related to parties. I would agree that the way in which it was written by the City Council has some question of what do they mean, so I have proposed some language for clarification, and it is presented to you in the report that I have submitted.
It's your report is titled with a case number, Planning, Land Use and Management Committee. It's this one here. For the record? Okay.
Are there any questions at this time?
Do you have any questions, Mr. Englander?
Probably stick around. Okay, I will.
Okay, so let me call the appellant, Niles Willits-Spollen, and then we will hear from the applicant and finally from Council District 3.
Good afternoon, committee members. My name is Niles Willits-Spollen. I'm the appellant, and I'm here before you today with gratitude. This matter, in one form or another, has been before me for 10 years.
Can you speak into the microphone, please?
Councilman Zine's office.
Yes,
sure, thank you. Councilman Zine's office has furnished 3 deputies over the past 10 years to help us. There's been hundreds of hours spent in city meetings, and who knows how much that's worth in terms of dollars. The reason I'm here today is just to give you a little bit of information. And thank you for your time beforehand. I support, let me first of all say that I support ARLUPA. ARLUPA is a federal law enacted under the Clinton administration, and I think it's consistent with all of the rights and freedoms that we support as Americans. I support the temple's operation. I think it's beneficial to the community, inherently beneficial, and has civic value. My issue here is not anything to do with worship or ARLUPA. I will support the temple as much as I can, even if I didn't live 5 feet from them, to have worship. What is at issue, and that I'd like to bring to your attention, is that as the zoning administrator had mentioned, the temple has grown over the years. It is 10 feet from my home and as far as the front door to this room to many other single-family dwellings. And as it has been indicated in the zoning administrator's decision, or rather South Valley Area Planning Commission's determination, I have it on page F8. However, the intent of the City Council and this decision maker is to permit a use that is proper in its location to R1 zoned, surrounded by single-family uses. And this addresses how many people can be at this location per square foot. It's also on this document, you'll see on page, where is it? There's a discussion here and an outline of the number of people that are permitted during the days of the week and the weekends, and that's on page C3. This is based on information that the temple has submitted, that on any Saturday, maximum occupancy for the site shall not exceed 75 persons. During weekdays, maximum occupancy shall not exceed 50 persons. 6 times a month, memorial service, bat mitzvahs, etc., 95 persons. It's very common for the temple to have sometimes 8 people, sometimes 80, sometimes 150 during the week, and this goes to the issue of the impact on the environment and the detriment and the displacement of homeowners. There's no parking facility there. There's plans and permission to use the church across the major highway of Fallbrook, but that presents a grave safety issue because children, all kinds of people, old, young, have to cross this major highway. I've seen it. People have almost been hit. I don't know why Mr. Stein's office hasn't stepped up and enforced the safety issue there. It's an accident and a liability suit waiting to happen, especially since city offices know of the danger. My concern is that as the temple does whatever they do, and my blessings to them, it brings a lot of people. Some of them walk, certainly, and many of them drive. So if we trade an hour for evening operation for the morning, what that means, if you can imagine it, is that people pull up, they park their cars, they chirp the button, they come inside, and some of what's done inside involves singing and prayer and so on. So that generates noise, and that's a considerable concern when you live 10 feet from the operation. Let me also say that I support the operation. Again, Mr. Shlomoff has been very hospitable over the years. I've enjoyed tea and conversation with him. I think that the people who come are benefiting from it. This is not a religious issue. It's not about worship that I'm contending. I support what they're doing. It's just a really, really detrimental impact considering the size of the operation. What's needed it would be parking and across the street and a traffic control signal. That has been written into the South Valley Area Planning Commission's determination. The temple has a limited number of days to see that they apply for that and secure some kind of parking. And I would ask the committee members respectfully to make their decisions and further meetings and so on contingent on concrete evidence that's furnished that I would gladly help with in the spirit of good faith to show that mitigation measures have not just been planned, but that they've been implemented and there are concrete results that are acceptable. Finally, I want to say that in the attempt that the temple's made to try to mitigate some of the noise and the exhaust and the emission pollution and the trash and displacing people from their mailboxes and blocking driveways has been to have people who come to the temple park on their adjacent property, also owned by the temple. But what that has done is it's brought upwards of 20 and 30 automobiles into a tight space on the adjoining property at 5710, creating a lot of emissions, a lot of noise, a lot of traffic, and so on. Thank you very much for your time.
Okay, thank you. Sure. Do you, Mr.
It's public comment, but I just wanted to clarify one statement that was made where you'd said that, I wasn't asking a question, I just wanted to make a statement. You'd said that CD3 or Mr. Zine's office failed to enforce some of the protections, and I just wanted to let you know that the City Council offices are not the body for enforcement. They don't choose or have discretion over what is and what is not enforced. There are enforcement bodies, whether that be building and safety, LAPD, et cetera. And I'm not looking for the rebuttal. I just wanted to clarify.
Thank you for the clarification. I believe that I don't know if the city offices, including Mr. Zine, is immune from lawsuit, though, in the case of injury or fatality. So I think it behooves whatever body of city government to inform the other to enforce. Thank you, sir.
Thank you. Thank you. Thank you very much. The applicant, David Carlat.
Good afternoon, members of the City Council.
Excuse me, sir. Sir, we try to keep a conversation going between whoever's speaking so that everybody could hear. You could please keep your comments to a minimum. If you wish to speak, you could speak outside. Thank you.
I'm here my name is David Carlat, C-A-R-L-A-T, and I'm here as a representative for the Siddardic Synagogue at 5726 Fallbrook Avenue, which is near Burbank, for those who know the Woodland Hills area. I've only been involved in about a week and a half in this case, and I can tell you, as someone who has just fought a 5-year battle in the city of Woodland Hill, West Hollywood, over a RLUIPA matter, that I've got a pretty good idea of what the limitations are that a city can and cannot impose upon a house of worship. And I was very pleased actually to hear the comments of the neighbor, because it sounds to me like there's not the miles apart that you might think when you look at this approval. I did outline, and you do have before you, the issues that I've pointed out that I think create real problems for the city. This is a poor temple. It doesn't have money to hire fancy attorneys to come in and make First Amendment cases, or expensive lobbyists to come in and make the case, as they probably should have been able to do early on. So in this case, I've tried to outline as best I can those issues that I think are most important, that have the biggest infringement on their First Amendment rights or cause the largest financial hardship on them. And the city attorney is correct that RLUIPA does say to the city that you must take into consideration the religious rights of a house of worship, and that what you do in terms of limitations is the least imposing as possible, and that it takes into consideration, when you look at the community interests, the interests of the house of worship also. And I just want to point out a few things that were said, because let me just say we support the motion today. We appreciate Mr. Zine's attempt to try to mitigate some of the impacts. We do believe that the Planning Commission did abuse its discretion here, that it did not take into consideration First Amendment legal rights of the temple when it listened to testimony from neighbors. And as a result, they imposed some fairly harsh conditions that we're hoping to get some relief from. Let me just respond to some of the things that were said. First of all, in terms of hours of operation, the temple is not asking for any hours of operation other than those they need to carry out their religious practices based on long-standing customs and religious rabbinic law for prayer and for other religious services such as bat mitzvahs and bar mitzvahs, britzes and weddings. And so to that extent, they're not asking for a party house where they can have a bunch of people show up at midnight and have a birthday party, by the way, which every neighbor could do anytime they wanted without restriction. And then as far as occupancy is concerned, it is no doubt about it, there is a problem with occupancy in the approval. The approval only allows 95 occupancy, but the sanctuary at the temple has got a building permit for 150 occupancy. And the membership is 200. So on high holidays in particular, they're being prevented from having half their congregation come to a service. And it seems to me unreasonable for the city to limit occupancy to less than that that's been approved by the fire department. Now, as far as parking, because obviously parking becomes the pivotal point on this question, it is also true that the conditions approved mandate that the parking be provided across the street at another house of worship, and then they've required that the synagogue spend the money to put in a crosswalk and a light in order to allow for their members to come from the parking lot of the other religious house of worship across the street to their own venue. I just want to point out the absurdity of that. they have on their own site enough parking, if they were allowed to use it, to provide all the necessary parking. They own the parking, the lot next to the temple that has already provided a parking proposal that would allow enough parking to take all the pressure off this community, both off-site and across the street and for street parking, if the community would just allow them to use their own lot for parking. And many mitigating conditions can be placed upon that in terms of how the cars are parked, if they're used by valet, or if it's going to be personal parking, and what kind of buffer can be created between the neighbors and the parking. And it seems to me just a no-brainer that to solve the concerns of the neighbors, which is parking in their neighborhood, and then the concerns about parking across the street, you just allow them to use their own space for parking. Also, one of the things that's kind of an ironic request is that they have valet parking on the Sabbath. Well, this is an Orthodox Jewish synagogue. Their members aren't supposed to drive to the temple on the Sabbath, and yet they're being required to pay a valet to be there for cars that aren't even supposed to come unless it's absolutely necessary. And so it's an example of another financial hardship that's really been placed upon this temple. The light and the walkway could easily cost the temple $100,000 to install. So what we're asking the council to do, and what we've asked Mr. Zion's office to do, and we feel that he's making a very sincere attempt to try to do so, is to merely respect the impact that these conditions have on their legitimate rights to have their house of worship and to pray. And to the extent that there's a condition that requires a review by the city, absolutely appropriate for that. I've brought before the zoning administrator a case. He didn't say there was, in his comments he mentions I only brought one case. I can bring other cases if that's necessary for the council, where we've modified the language of the plan approval condition to allow what's called a proof of compliance condition. It basically accomplishes exactly the same thing, but it takes the $15,000 cost that it costs today to submit a plan approval review. I don't know if all of you are aware of this, but you know, a few years ago, a plan approval cost like $586 to file. Today it's $6,000, but by the time you filed the $6,000 fee and all the mailing fees and all the notice fees and all the maps and all the other requirements, it's about $15,000. It just seems terribly onerous for the temple to have to come up, a temple too poor to hire an attorney to come and represent today, to have to come up with another $15,000 next year to come back before the planning department to show that they're in compliance. If the adopted condition that I've proposed, which has been adopted twice, by the way, in front of me, for other cases for commercial uses, was adopted, there would be no fee unless the zoning administrator determined that a public hearing was required after review of the documents. So I would ask that any of these mitigating measures to take some of the financial burden off of the temple and to allow them to have legitimate hours of operation for house of worship are all that the temple is really asking. And if there's a way to mitigate this parking solution, I can tell you that the city attorney personally suggested to me that maybe a formal mitigation with a representative from the city attorney and some neighbors and the temple leadership might be able to work out this parking arrangement to everybody's satisfaction. Thank you very much.
Thank you very much. Any questions, Councilmember Englander, for the applicant?
No, thank you.
Now we'll hear from Council District 3, Daniel Skolnick.
Thank you, Council members. Daniel Skolnick for Councilmember Dennis Stein. I'd like to thank the City Attorney and the Planning Department for their work on this issue. CD3 supports the ZA's report, which meets the intent of Councilman Zion's motion to bring conformance to RLUIPA. And so the recommendation to the committee is to grant in part and to deny in part using the recommendations from the AZA.
So you're recommending that we grant in part and deny in part the recommendations from the ZA?
Correct.
As submitted here today. Okay. Mr. Englander?
Yeah, just for clarification on that then, because there are, under number 3, recommendation not to modify condition as requested unless specifics are provided on a number of events, potential attendance, and duration of the event. So to put the community on notice to these activities and to mitigate the potential of the after-hours impacts. So it's saying not to modify it unless. And so I don't know if that we've gotten anything back from the applicant on that item.
So in this particular instance, council member, we haven't received clear material from the applicant, which city staff can then work with and create appropriate conditions, or work with the council office to create appropriate conditions. We're not saying no to this necessarily, but the thing is that, you know, until this time, we don't have any clarity as to what exactly they need. Okay.
My other questions were on the, let's see, on number 3, again, it says here, the limitation on the building occupancy and response, it says the ZA suggests not to modify the condition unless the project proponent can justify why they'd have the right to have the place assembly that operates. You know, have they provided that either?
No. Again, it's another situation. We're waiting for the applicant to clarify and to bring more materials.
Okay. And then on number 6 was the party type. One thing the ZA says is clarification of term, and it doesn't seem that that was done clearly. And it says that the response to that is the condition was not met. Project proponent did not contest it, nor did they take the issue with the condition, but it shall be interpreted to mean a social gathering, so for which religious nature and activities are incidental. So do we have a further clarification from the ZA, or you're just giving us that clarification for the record?
If I could direct that question to the zoning administrator.
Yeah, that's
to clarify,
what I'd like to do.
I'd prefer that. Can I bring
Yes, please.
Mr. Brown?
So is that your response is just, your recommendation is just to clarify
Yes.
what a
just to
party
clarify,
is
yes.
on the record? Okay. I'm assuming this is just a typo, but it's on the project proponent's contention number 7, under condition number 12, the second sentence that says this is designated to prevent the use of the synagogue of their 2 properties as one venue and hopes to eliminate use of the, is that corner lot for on-site parking? It says Comer lot.
Yes.
It's corner lot?
That'd be corner.
And I think that's all that I had on here. That was it.
Thank you, Mr. Englander. And I don't have any further questions. Mr. Englander, would you like to make a motion? Or?
Yeah, I'd like to make the motion that we go ahead and accept the ZA's report and recommendations as modified.
Okay, so the action of this committee will be to grant in part and deny in part by adopting the motion made by Mr. Englander of the appeal. And so we're granting in part, denying in part the appeal, and adopting the recommendations by the zoning administrator. Okay. With no objections, so ordered. Next item.
That would be public comment, Councilman.
No, we're done. No cards.
We're good. No public comment. Anything on that last item, City Attorney? Any final thoughts on the...
No.
Okay, great. Thank you very much. This meeting is adjourned. Thank you.